All right, so it's now 3 p.m. in the UK, 10 a.m. I believe in Bogota. And so we'll get started. Thank you everybody for joining us today. I'm Samar Shams. I'm a partner in the Immigration and Global Mobility team at Spencer West. And today we're going to be talking about visitors, and in particular, we'll focus on some of the permitted business activities as well as upcoming changes. I am delighted today to be joined by Luis Pinilla from Bogota in Colombia. Luis, would you like to say hello?
Hello, Samar. Hello, everyone. Thank you, Samar, for your kind invitation to be with you.
So Luis and I are going to talk about the visitor rules, and you'll see why it's very special indeed that Luis is joining us from Colombia a bit later in the presentation. Now, those of you who have attended my webinars before will know that it's quite informal. I do welcome questions. I would invite you to put them into the chat, and I will be checking the chat every once in a while. I don't have a moderator today, so you will have to excuse me if it does take me a couple of minutes to get to your question in the chat, but I will try to address them generally as we go, so feel free to ask. This session is being recorded, so keep that in mind when sharing information. Otherwise, that's it. Let's give you an overview of what we're going to talk about today. So first, we'll just give an overview of visitors generally to the UK and some eligibility criteria when entering as a visitor. We are going to talk about visa nationals versus non-visa nationals, as well as the use of e-gates. We are going to drill down into the permitted business activities, and then we'll talk about the electronic travel authorizations that are planned for later this year and next year in the UK and the EU. So in terms of a general overview and eligibility, a visitor to the UK has to intend to leave within 6 months of the date of entry. You must not live in the UK through frequent or successive visits. We'll talk about that a bit more later. You must not make the UK your main home, and you must not be paid from a UK source. So travel and subsistence expenses are allowed to be paid from a UK source, but you can't be paid otherwise, and certainly not for work. You have to have sufficient funds to maintain and accommodate yourself during your visit, and also to cover the costs of your return or onward journey. Okay, so I'm just going to leave it at that in terms of the basic eligibility, but we will return to some of these points later in a bit more detail. Let's talk about the different types of visit visas. So people often ask me for a business visit visa. There actually isn't technically a business visit subcategory of visit visa in the UK anymore. Business visitors come in as standard visitors is the term, but business activities are permitted to standard visitors. There are other subcategories of visit visas, and a very interesting one is the permitted paid engagement, or PPE visa. And as the name implies, permitted paid engagement, the permitted paid engagement subcategory allows for payment from within the UK. It's only for up to 1 month, an engagement in the UK of up to 1 month, and it's for experts within certain sectors. So it is limited to academics, litigators, artists, entertainers, sports people, and fashion models. but within those sectors, it really can be quite useful. So it's definitely worth keeping in mind. There's also a marriage or civil partnership visa, visit visa. Now, this is not the visa to use if you intend to marry in the UK and then live here, okay? If you want to, say, marry somebody who has settled status in the UK or is a British national, and then you're going to live here together, you need something called a fiancé visa. The marriage or civil partnership visa is for people who just want to marry in the UK and then reside elsewhere. And it would be a 6-month visa. There's also transit visit visas, as you would imagine. And visit visas can be granted for varying durations, up to 10 years. Now, that doesn't mean that you can spend a continuous period of 10 years in the UK as a visitor, but the visit visa itself would be valid for 10 years, and you could use that for entry of up to 6 months each time you visit. Okay. So the main thing to keep in mind is, of course, that work and selling is prohibited. And I'm just going to repeat that. You're not allowed to work in the UK on a visit visa. And the UK government defines work pretty broadly. So, most people think of work as working as an employee, but somebody might assume that they can, come in and do some work on a self-employed basis as a visitor. You can't. Self-employed work is also prohibited. Work placements count, internships count. There is a specific category you can use for internships. It is possible to bring interns to the UK for work, but they can't come as visitors. It's a specific separate process. They don't fall under the visitor rules. And work would also include short-term cover for a UK-based role. So, for example, your UK operations director, excuse me, your UK operations director is quitting. You want to bring your Italian operations director in just to handle the transition, support the team a bit. They're going to be going in and out. They're not really going to be based in the UK. They're still going to be based in Italy. They're still going to be paid from Italy. Still, that constitutes work, and you would need a sponsored worker visa for them, in fact.
Samar,
yeah.
I may. I've been paying attention to everything that you just said, and so that everyone knows, Colombian nationals were exempted from UK visas as of November last year. I had the opportunity to visit you, meet you in the UK just a couple of days after that new measure entered into force. You mentioned before that if you have a visa, you're not allowed to stay over 6 months. But what about people like Colombian nationals that we do not need a visa? Does that time limitation still applies the same?
It does still apply, yeah. So we'll talk a bit about visa versus non-visa nationals later, but there would always be a limit of 6 months every time you enter the UK as a visitor, even though you don't need a visa before traveling to the UK. Once you rock up at the border and come in, you would be expected to leave within 6 months.
Can I ask you the following?
Mm-hmm.
Since we're so close to the US, most of the and because of my practice, I'm also allowed to practice in the state of New York in the US. Many people are very concerned about visiting the US for a long period in time. What about staying in the UK for that long, up to 6 months? My concern is the following: if I stay 6 months and then I travel back to Colombia and I want to re-enter the UK, probably in 1 week or in 1 month or in 2 months, do you think that I'll be let in, or there will be some kind of red flag? And well, you just left before, right?
Yeah, so that's a really good question. So I'll just emphasize before we leave this slide about work that selling goods or services to the public is prohibited. And now let's talk about the time limits in a bit more detail. I think those are really good questions because it's something that's often, people are often confused by, actually. So let's talk about the time limits. Thank you, Luis. There is not, people often think that there's a time limit of 6 months out of any 12 months, for example. You know, they'll call me and they say, oh, I've been really good. You know, I've always made sure, I've always counted my days and I've never stayed more than 6 months in any 12 months. That's actually not the rule. There's no specified maximum period within, there's no specified maximum time you can spend in the UK within a period. So it's not 6 months out of any 12. It's that each visit has a maximum period, and this will vary on the subcategory of visit visa, but it's usually 6 months. So, you know, in the example that you gave, if you're coming, you know, as a non-visa national now, as a Colombian national, non-visa national, you know, arriving at the border and entering the UK, you would have to leave within 6 months. And the actual rule is, unfortunately, what I would refer to as a wishy-washy rule. It's not the most, it's not the clearest rule. So the actual rule is that you must not be living in the UK through frequent or successive visits, okay? Now, what does that actually mean? So in the guidance that the Home Office publishes for its own caseworkers, for its people who are deciding, they're going to be looking at the purpose of your visit. Does that match up with your intended length of stay? You know, you mentioned we met at a conference last year. You know, if you showed up at the border and you said, I'm coming for a conference, and then they asked, well, how long are you staying? 4 months, that doesn't make sense, does it? Right? So that's one thing they're going to be looking at. Is the length of your stay commensurate with the purpose of your visit? They're going to look at the number of visits. Are you actually spending more time overall in the UK than in your home country? And again, it's not a specific limit out of any specified period, but overall, are you spending more time in the UK than in your actual country of residence? And what's the purpose of your trips when you leave the UK? Are you leaving just to be able to seek re-entry for another 6 months? So, you know, are you staying 5.5 months, taking the Eurostar to Paris, and then traveling back to the UK? And are you doing that again and again?
Samar, I assume that I could anticipate the following questions at entry by the immigration official. Can you please show me your return plane ticket? Can you please show me your hotel arrangement, things like that?
Yeah, exactly. So in terms of what you might be asked at the border, the border force officer is always going to be trying to see if you meet those basic eligibility criteria. So that's exactly the type of thing they would ask. And then they're also going to ask about your intended activities to see whether they constitute work or not. So that's exactly right. They'll also look at whether you've been refused UK visas before, because you'd be considered higher risk, and they'll definitely scrutinize you more if you have. If anybody else has questions, please do feel free to put them in the chat. I'm happy to take questions as I go. So please do share your questions. Now, I am not a doom and gloom lawyer. I'm not trying to scare people into following the law, but it is important to know, you know, what happens if you breach the conditions of your leave as a visitor. So we've discussed you're not allowed to work as a visitor. And you're not allowed to sell goods or services to the public as a visitor. So what happens if you do work or sell goods or services to the public? Well, the UK employer who might be paying you for the work would be subject to criminal penalties. So people responsible within that organization could be subject to up to 5 years in prison, an unlimited fine. The Home Office can now close down business premises. So a Home Office compliance officer an immigration enforcement officer can come to the business premises and close it down for 48 hours. In that time, they'll go to the judge. The judge can then close it for up to a year. And there has been a recommendation to the Home Office to use this power more than they have traditionally. So it is a real power that's used. Honestly, people do not tend to go to jail for illegal working. They do have that power. So, you know, it's important to know that it could happen. It's very, very rare, if, you know, almost never used at all. But I think premises closure is a real risk. And I have seen instances of that. The other thing is that if the employer who's responsible for the illegal working, if they are a sponsor of non-UK national workers, then they could lose their sponsor license. If they don't have a sponsor license yet, they could render themselves ineligible to obtain a sponsor license. They could pay civil penalties of up to £20,000 per illegal worker. And that can really add up, you know, 5 of those, that's £100,000 fine. There aren't a lot of, you know, medium or small businesses that could necessarily even survive that type of fine. And then the Home Office also publishes the names of businesses that are liable for fines. Did you have a question, Luis?
Yes, Samar, I was going to ask you the following. I believe that there could be like a gray area about the following. What if I'm also a professor of law? What if I'm invited to teach or to participate in an academic event? Will that be authorized? Even if, for example, I don't get paid, but the entity that is inviting me will cover at least part of my expenses?
So there are some specific allowances for academics. I'll just address the consequences of illegal working for the employee. And then we can talk a bit more about the activities, but that's a really good question. And it highlights that it's really worth case-by-case analysis of what you want to do as a visitor in the UK, because although generally work is not allowed, there are a number of exceptions, and some of them do apply to academics. But first, let's just discuss what would happen to the individual who might be working illegally as a visitor in the UK. So the individual themselves could be subject to up to 6 months in prison, and their wages from that illegal working could be seized as proceeds of crime. So avoid. And, you know, you can always get a work visa if the purpose is work. And obviously, I'd be very happy to help with that. So let's talk a bit about visa nationals versus non-visa nationals before we get into the nitty-gritty of permitted activities, because this is close to Luis's heart. As he mentioned, Colombian nationals have recently been removed from the visa national list. So a visa national is somebody who needs a visa before traveling to the UK. So you have to submit an application. It's going to involve an online application form, submission of documents, basically showing that you meet those eligibility criteria that we discussed, and potentially attending a biometrics appointment before the Home Office then processes your visa and hopefully grants your visa when they decide it. So visa nationals have to go through that process before coming to the UK. Technically, what they're granted is called entry clearance. The visa is entry clearance. Non-visa nationals can just come to the UK border, at least for now. We'll look at how this is going to change in the future a bit later, but at least for now, non-visa nationals simply travel to the UK and they are granted leave to enter or permission to enter on arrival in the UK, usually for 6 months, up to 6 months. Okay, and so the list of countries whose nationals are visa nationals is actually in the immigration rules. And hooray, Colombia was removed from the visa national list in November last year, as were Guyana and Peru. If anybody has any questions, do jump in. Otherwise, we could talk about e-gates. So everybody loves to use the e-gates if they can, if their e-gates are operational. Now, what do you need to be able to use the e-gate? You need all of these things, all of these starred items. This is not an or list, this is an and list. So you need a biometric passport. How do you know if your passport is biometric? If your passport is biometric, it's going to have this symbol on it. And it will usually be on the front. This is my US passport. And there's the biometric symbol. Okay, so you need a biometric passport. You have to be age 12 or over. So if you're traveling with younger children, you're all going to have to go as a family into the line where you talk to the border force officer. You're not going to be able to use the e-gates. Families go together and are assessed by the officers. You also have to be of a certain nationality or a registered traveler. So you have to be a British citizen. British citizens can use the e-gates. You have to be, or you could be a national of an EU country or Australia, Canada, Iceland, Japan, Liechtenstein, New Zealand, Norway, Singapore, South Korea, Switzerland, or the USA. Now, this list is basically a list of jurisdictions that share data. And it used to be called the 5 Eyes, as in eyes, like we can see. And there were 5 jurisdictions involved. That was the EU, Australia, Canada, the US, and the UK. EU, Australia, Canada, US, and UK. Yeah, the 5 Eyes. But now it's extended to these other jurisdictions as well. And basically, because of that data sharing, the UK is happy for nationals of these countries to use the e-gates. And then finally, there is something called the Registered Traveler Service. I'm not going to go into a lot of detail on this, but it is a service that's available to nationals of certain countries. So it's not available to nationals of all countries, but to certain countries where an individual is a frequent traveler to the UK, a frequent visitor, and they have a visa in place, because these will be visa nationals. They can also use the e-gates, but it's quite specific. Now, what else do you need to use the e-gates? Well, the e-gates have to be working, which they often aren't. So don't rely on being able to use the e-gates, not having a conversation with a border force officer. I would say always be ready to have a conversation with a border force officer. Oh, Luis, you're muted.
Thank you, Samar. I was just going to say the following. In the previous slide, you just mentioned vis-a-vis non-visa nationals, and now you're talking about e-gates as if they were different. You just mentioned that do not expect that you're not going to be interviewed regarding the type of questions regarding what you're going to have to live, what you're going to have to go through at the moment of arriving with the migration officer. Is it exactly the same thing between the 3 of them? Visa holder, non-visa holder, and then if you are just using e-gate?
So technically, yes, it should be the same. I would say racism is alive and well in the UK, unfortunately. So people are not always going to be, all people are not going to be treated the same in that regard. But yeah, so each time somebody's entering as a visitor, whether they're a visa national or a non-visa national, they are having to meet the same eligibility criteria. When you're a visa national and you're applying for a visa beforehand, you're demonstrating in your application that you meet the criteria. If you're a non-visa national and you're coming to the border, you could still be required to demonstrate in the same way that you meet the criteria. So non-visa nationals would do well to carry with them the documentation that visa nationals would generally use to support their applications, their visa applications. So for example, to go towards intention to leave within 6 months, you would provide your return or ongoing ticket. You could provide, if you are a business visitor, if you're coming for business activities as a visa national, you would provide a letter from your employer in your country of residence saying, you're going for these purposes, or a letter from the UK entity that's inviting you as to the purpose of your visit, and exactly what you're doing and how it falls under the visitor rules. If you're a non-visa national, you would carry that letter with you in case Border Force asks you why you're coming. It will help you demonstrate why you're coming. So you would have documentation to meet each of the criteria, whether you're a visa national or a non-visa national. Is just when are you presenting that documentation? It's a really good question.
I was going to ask you the following, Samar. In the US, sometimes people ask me, what if I want to apply for a visa to the US? Does it make any difference if there is an invitation letter to the US? And my answer is, it all depends. But usually when you get an invitation letter, it's from someone that it could be very close to you. I'm talking about like a boyfriend or a fiance. And at the end, if you show this kind of letter, it may just raise some additional questions. And at the end, they will find out that you have a significant other in the USA, or in this case, in the UK. What do you think about this kind of invitation letters?
Yeah, it's similar in the UK. One very common reason that people are refused entry as visitors is that they have a partner living in the UK, a spouse or a unmarried partner, a longstanding partner living in the UK, and they come to the border, and the border force officer says, "Why are you here?" "Oh, well, I'm visiting the love of my life." Well, the border force officer is not going to be convinced that you're ever going to leave the love of your life just because of the visa rules. So I would actually suggest, when somebody is coming for those kinds of relationship reasons, romantic reasons, that it's good to carry with you documentation of your commitments in your country of residence. So why you, even as much as you would love to, you will not be able to stay in the UK, at least on this visit, with your wife or husband or partner, because you have a letter from your employer in Colombia saying you're expected back at your usual place of work, which is the office in Bogota, on this date to carry on your ongoing duties, and maybe you'll have pay slips and bank statements evidencing your employment as well.
So Samar, just to go to the point, what you're saying is that it is better to show, if I'm visiting the UK, that I have a job in Colombia and that my employer is waiting for my return to Colombia. I mean, I will just get back to work as soon as I return to Colombia.
That's right. Yeah. And a work commitment is going to be the most convincing to the border force. So, unfortunately, women are often at a disadvantage because they're statistically less likely to be working. They might be supporting a family, even extended family, in their country of residence. And that's a very real commitment, but the border force will not accept it. But they're generally accepting of documentation evidencing a job in your country of residence that you have to go back to. Great questions. If any other participants out there have questions, please do let us know. Otherwise, let's go for the main attraction, what everybody's here for. Let's talk about the permitted business activities. So this is the main list of the general business activities that are permitted to standard visitors. Again, there's no specific business visit subcategory in the UK. So business visitors enter as standard visitors and are allowed to undertake these specific general business activities, So attending meetings, conferences, seminars, interviews. I am going to run through this list, but I want to say as well, I just want to highlight, as I mentioned before, there are always exceptions. So it's always worth getting somebody to look at the visitor rules for you, because although these are the general business activities that are allowed, there are specific allowances, as I mentioned, for academics. There are specific allowances in other sectors as well. I'll talk about the ones for academics a little bit later. But these are, you know, as the name of the list implies, the general business activities that are allowed. So attending meetings, you can present a talk as long as the organizer is not going to make money out of it. And a kind of general way, useful way of thinking about visit visas, what's permitted, what's a permitted activity and not, is like, is somebody going to be making money out of it? Is it a commercial activity? So you can present a talk, but not if somebody's kind of charging entry to people for, you know, to attend your talk. You can negotiate deals and sign contracts. You can't start working in accordance with those deals or contracts whilst you're in the UK. You can attend trade fairs, but just to promote your goods or services. So, for example, I actually have invented a pair of overshoes for women cyclists. It lends a flat sole to a high heel. And so I go to cycling exhibitions in the UK, national cycle shows. Now, if I were a visitor to the UK, I could attend these trade fairs. I could even have a stall potentially, but I could not then sell my overshoes from the stall to the public. Okay, I could just promote the product, but you can't sell as a visitor. You can carry out site visits and inspections. You can gather information for your employment overseas. So some types of research, like market research, might be allowed. You could be briefed on the requirements of a UK-based customer, but again, can't then just start doing the work whilst you're in the UK. You get the briefing, get the information, and then you start doing the work outside the UK. And then the last one's a really interesting one. It's an allowance for installation and servicing of commercial equipment, hardware and software, pursuant to a contract of purchase, supply, or lease. Now, this means that if there's a UK entity that has contracted to buy or provide in some way the equipment, if the contract involves an installation provision or a servicing provision, then an employee can come from overseas. The contractor's employee can come from overseas to undertake that installation or servicing. And it also applies to a subcontractor. So if there's a subcontractor who's installing or servicing equipment, then they can come for the purpose as well. There's a question in the chat that asks, what about performing your overseas job duties while staying in the UK temporarily as a tourist? Now, this is such a good question. This is an age-old visitor question. And I was actually involved in the streamlining of the visitor rules, must be like 10 years ago now. I don't know. Boris Johnson was mayor of London at the time, and it was a project of his. And we did make the visitor rules a lot better. But one thing that we did not quite iron out was this question of whether you can do your overseas work whilst you're in the UK. Now, I would say the technical answer is no. You know, you can't. It's certainly not. It's certainly not explicitly allowed in the UK visitor rules, as it is in some other jurisdictions. Some other jurisdictions explicitly allow it. So really, you should not be doing that, and particularly if you have UK clients. You know, if you're coming as a tourist, they will expect you to be undertaking tourist activities and not working. There's no digital nomad visa in the UK either. If you want to be self-employed, you could set up in business in the UK. You could incorporate a business and then sponsor yourself to work, or you could use the expansion worker route. But you really should not be coming into the UK as a visitor and working.
Samar, now that you're talking about incorporating a business in the US, can I do that as a visitor? Can I open, for example, a bank account?
So you can incorporate a business, so you could be a director of a UK business, but you would have a really hard time opening a bank account as a visitor in the UK. Even with permission, it takes a few months to open a bank account in the UK. So I wouldn't expect to be able to do that. And that, when I say that, I mean a proper bank account, FCA regulated UK bank. There are electronic money transfer accounts. You might be able to open one of those more easily, but certainly a proper bank account, I would expect that you would have a very hard time doing that as a visitor to the UK. Okay, so there are specific intra-corporate activities that are allowed. And this is for employees who are part of the same corporate group internationally. Okay, so there's a UK entity, an overseas entity, and they're linked through common ownership or control. They're part of the same corporate group. Now, for those types of visitors, employees of those types of overseas companies, they can come in and work with their UK colleagues on a specific internal project. They can't be working with clients. So what they could do is advise, consult, troubleshoot with their UK colleagues. They can share their skills and knowledge with their UK colleagues. They cannot be working with clients. And one thing to keep in mind throughout is that even where these business activities are permitted, you shouldn't be paid from within the UK for them. So, in this example of intracorporate activities, employees of the overseas company should still be paid from their overseas employer, paid by their overseas employer, not from within the UK. All right, let's talk about training. There are some allowances for training. But the thing to remember about training is that it has to be classroom-based or familiarization and observation. It cannot be on-the-job training for obvious reasons. There would be super gray areas between, are they working or are they training? It can't be on-the-job training. So it has to be shadowing, but not actually doing anything, or classroom-based. So overseas employees can come to the UK to provide training to UK colleagues in the same corporate group, again, on a specific internal project. Employees of an overseas company can receive training within the UK in work practices and techniques that are required for their overseas employment. Now, the training that they receive in the UK cannot be available to them in their home country, if you're using this allowance. And then an actual training company that's contracted by an international corporate group can send an employee to the UK to deliver training in line with that contract, that international contract. Any questions? Yeah.
Question. Sometimes for foreigners, it is a little bit difficult to try to explain what they're going to do because they usually like the word work. I'm going to work.
Yeah.
Can if we can anticipate that, can the local company in the UK provide like a letter stating this is just in case that the immigration official is going to ask you about what you're going to do, shut up and show this.
Yeah. As I said, a letter from the entity in the UK that's invited you, whether that's an employer or somebody who's running a conference that you're attending, is always useful. And in addition to, I draft these letters for people all the time. And in addition to setting out exactly what you're doing and how it falls under the permitted activities, there's always going to be a line in there saying it doesn't constitute work. We're also going to say you don't intend to make the UK your main home. You have this onward travel. So yeah, definitely it helps to put it all in a letter.
Absolutely. So many times I get to see the same thing in Colombia. People arriving in Colombia, what are you going to do? I want to work. No, you're not going to work. You
And
have to
it's
have,
not going to work. They think of it as work. They
right.
think of it as work. It's normal to, in like normal language to say work, but it is often genuinely a business activity that's permitted and not actually work. So it is important not to, gleefully tell the border force officer that you're delighted to be arriving in the UK for work. Yeah, agreed. So just to emphasize, you can't be paid from within the UK other than for reasonable expenses and to cover your travel and subsistence. There is this great exception, but tread carefully because it's very specific, okay? So if there's an overseas company and it's contracted to provide services to a UK company, and the majority of the contract work is carried out overseas, then the employee can be paid for their time in the UK as long as the payment to that employee is lower than their overall salary. And keep in mind that the activity that they're being paid for still has to fall within the permitted activities. So it could be a meeting with a client because meetings are allowed. Okay, so it's a very specific exception. So if you were an employee of a law firm based in Belgium, you could enter the UK and be paid for a meeting with a client. The client's in the UK, they're paying for that meeting. That's okay, as long as the payment for the meeting isn't in excess of your whole salary. All right, so it's quite useful, but very specific. All right, let's talk about electronic travel authorizations. This is really a big change that's coming up that I think there's just so much going on that it hasn't gotten a lot of attention, but it's going to kind of really affect the way millions of people travel in future. So an electronic travel authorization is not a visa. It's a permission to travel. Oh, I've just seen there's another question. Let me see. Oh, hi, Shafina. A question from Shafina. If we're just paying for travel and subsistence, then do we still need to obtain, verify, and check their right to work documents, even if they're not working? That's interesting. So they're coming in as a visitor, but they have the right to work. I'm a bit confused if they have the right to work if they're coming in as a visitor, because as a visitor, they wouldn't have the right to work. So you couldn't really check their right to work. Oh, so Shafina has specified this is the permitted paid engagement route. Yes, I would still check them under if they're coming in on permitted paid engagement. I'm just trying to think if that falls under any of the Home Office guidance for checking people's right to work, how you would check a permitted paid engagement visitor. Might need to get back to you on that. Good question. No worries. All right, so let's go back to electronic travel authorizations. So they are not visas. It's a permission to travel, okay? And non-visa nationals are going to need this permission to travel before arriving at the UK border in future. So everything I've just said about visa nationals need to apply beforehand, they fill out the online form, there's submission of documents, etc. And then they're granted a visa, but non-visa nationals don't need to do that. They just show up. Well, that's all going to change. In practice, this system of electronic travel authorizations is being introduced. And so non-visa nationals like Colombian nationals now, EU nationals, EEA nationals, coming to the UK, they're going to need to first be granted Electronic Travel Authorization, ETA is the UK's version of it. And this is being rolled out now to certain nationalities, and it's going to continue to be rolled out throughout this year. And it should be fully operational by the end of next year, end of 2024. And the way it's going to work is that you will complete an online form. You will provide biographic information, biometric information. You're going to provide contact details, and you're going to pay a fee. We don't know yet what the electronic travel authorization fee for the UK will be, but there will be, we do know what it will be for the EU. It might be similar. We'll talk about that in a minute. And basically, you're not getting on the flight unless you've done this beforehand. It's going to be somewhat similar. I don't know if anybody who's joined the webinar today had to complete a passenger locator form during COVID times. You know, in practice, I think it's going to work quite a bit like that, but you will have to do it before traveling. So it's going to be a big change for a lot of people, and I think a big shock for a lot of people. I think a lot of people are going to try to travel without electronic travel authorization, and so there will be an adjustment time. Does anybody have questions about the UK's plans for electronic travel authorization? I'll talk about the EU plans, and then maybe we can talk a bit more broadly about what it means in the longer term that more and more jurisdictions are requiring these permissions to travel from visa exempt or non-visa nationals. So the EU version applies to 30 countries within Europe, and it's going to be called the European Travel Information and Authorization System, ETIAS. And it's for nationals who are exempt from having to apply for visas to 30 European countries. It's going to include UK nationals who are currently exempt from having to apply for visas to visit Europe. Now, it was supposed to be rolled out this year. It looks like it's being pushed back to next year. An ETIAS would be valid for 3 years, but it's linked to your passport. It might be the same for the UK system as well, so that if you change your passport or lose your passport, etc., you would have to get a new ETIAS in order to travel. So that's something to keep in mind. And the European program, we have a bit more information about what they're going to be asking for, and it will include personal information, information on your education and occupation, details of your intended travel and stay in ETIAS countries, and your criminal convictions, your past travel to war and conflict zones, and whether you've ever been required to leave any country. I think this is really significant. So the ETIAS, the fee for the ETIAS authorization will be €7, so it's quite low. But I did want to just talk a little bit about the significance of these travel authorization systems more broadly. One has been in place in the US for a long time now. It's called ESTA. And Luis, I don't know, maybe you have some comments on how ESTA works. One thing I'm afraid of is that it's going to be used to refuse people on the basis of, prior criminal activity, that might not be very well defined. So I'm a bit wary of these programs and how they might be used. Do you have any thoughts on that, Luis?
Well, not really. We just know, well, taking into account that most of my clients are Latin American nationals, I don't get to see many ESTA petitions. All that I know is that, as you just pointed out, there are some forms that you need to fill out before traveling to the US, even despite the fact that you don't need a visa to enter the US, right? And second, let's just say that what if you failed? What if the ESTA is not authorized? You need to go and get a visa. I wanted to ask you the following, Samar. You just mentioned the criminal convictions. and that could be an obstacle to get the ESTA to enter the UK. I think that you just mentioned, is it like very broad, or we're talking about, I mean, any kind of crime, or there are some specific types of crimes that are like an absolute no entering to the UK? I'm just going to give you an example. Let's say that when I went back in time, when I was 18, 19, I got in trouble with one of my classmates at the university, and we were arrested, something like that. Would that, if it is not a felony, if it is just something minor, a misdemeanor, or anything that is not directly a crime, would that be a direct no go to the UK?
Yeah, so that's a really good question. So if you were refused an electronic travel authorization, then you would need to apply for a visa, even if you are a non-visa national and you wanted to visit the UK. And in terms of the criminal activity that's relevant, when on the UK application forms, it always asks about criminal activity. And it asks about penalties generally. Now, nobody thinks about their speeding tickets and their parking tickets, but actually, technically, on UK visa application forms, you are supposed to declare those. They are considered what are called fixed penalty notices. And although they are unlikely to result in a refusal in and of themselves, they do have to be declared, because they will be considered a mark on your character and a potential reason for refusal if they're very frequent. So they'll consider the frequency and how recent they are. Now, in terms of your question, your example of a historical infraction, the criminal conduct is generally considered under a part of the immigration rules called general grounds for refusal. And the general grounds for refusal list various types of criminal activity and state that, depending on the level of criminal activity and how far back in time it is, it states that a visa application must be refused. So, for example, for a penalty that leads to a jail sentence within the last 2 years, you would be refused a visa. So it's a specific analysis of the level of the infraction, which is generally assessed by the severity of the sentence and how far back in time it is. You can also be subject to, effectively, because you're mandatorily going to be refused a visa for certain criminal activity, you're basically subject to a ban from the UK. You can be, so you're effectively banned from the UK. You can effectively be banned from the UK for instances of breaches of immigration conditions. So again, if you are a visitor and you were working, then you could be refused a visa. So let's say you're a performing artist and you show up at the border, they ask why you're there. Oh, I'm just here on holiday. I want to see the sights in London. Okay, great. I'm just going to look up some information about you. Oh, I see here that you gave a concert in London last year, but look, you were on a visitor visa, so that's a refusal right there, for example. You can be banned from the UK for up to 10 years under the general grounds for refusal. 10-year bans generally apply where their home office perceives misrepresentation or fraud. So if they think you're lying to the border force officer in that conversation with them, or some of the information in your documentation was misrepresented, or you have actual fraudulent documents, that would lead to a 10-year ban. So that's a very long answer to a short question, but I hope it was helpful. We're nearing the end of the time now, so I'll just give people one more opportunity to ask any questions. I see there is another question from an attendee, and that is, are there any particular visit visa conditions that apply for visiting researchers, especially those coming to undertake research at UK universities? Now, thank you for this question, because actually I forgot to go back and talk about academics, didn't I? There is something for researchers. I can't remember actually, apologies off the top of my head, exactly what it is, because the visitor rules are very, very detailed. But yeah, one of the academic allowances does apply to researchers. Another academic allowance is for academics who are on formal exchange programs. So academics who are on formal exchange programs can use the visitor route to come and, act as lecturers, etc. I imagine it would cover researchers as well, but I'd have to just double check. And they could come in as visitors. They would still have to be paid from their overseas, by their overseas employer, not from within the UK. But that's one allowance for academics. There are also, academics accompanying student groups. There are allowances for that type of thing. So I hope that's been helpful. Are there any other questions? Sorry, I wasn't able to answer everything off the cuff because they were very, very good questions, but really very specific, as are the rules. And so I would not be totally comfortable just responding off the cuff. If nobody else has questions, then I'm just left with the responsibility of saying thank you very much. And thank you so much, Luis, for joining us as well.
Thank you, Samar, for your kind invitation.
And you have there both my details and Luis's details. If you want to get in touch, please don't hesitate. So thank you so much for coming, everyone, and we hope to see you at another webinar. Bye.
Goodbye, Samar.
Bye.